I call the Honourable Minister Chester Burrows.
Thank you, Mr Chair, and I just want to address 3 points that have been raised by the previous 2 speakers and put their minds at rest in respect of those issues. In respect of Clause 27, the point was made that the Children's Commissioner had made a submission that the best interest of the children was not mentioned in the bill. The fact is that Clause 27 amends the Care of Children Act of 2004, and the paramount principle of that Act is what is in the best interest of the child. So any decision made under any decisions under these clauses that go on to amend the Care of Children's Act of 2004 that the judge is making, he must consider what is in the best interest of the child. So because it is not mentioned in this bill, does not take anything away from the fact that when the Care of Children Act is amended by this bill, the judge will have to make those considerations. Another point was raised, or question was raised by the previous speaker, Mr Little, around how the cost of child contributions were going to be recovered by the court, and I had quite extensively, I think, covered that in my previous speech, which said that the regulations which will accompany the bill make provision for the judge to be able to recover no more than 2/3 of the cost of the child's the cost of counsel for the child, and the judge can apportion that. Will sort of by default apportion that 50-50, but has the opportunity to move that or to remove it completely if he believes that there is hardship or that it's not in the best interests of the child to be able to try and recover those costs. So then the question was around what does serious hardship mean, and as this isn't defined within the bill, then how could a court possibly understand what serious hardship means? Now, the term serious hardship is a term that is used in other legislation and as interpreted and so is interpreted by judges now in the courses of their deliberation in respect of these other acts. And 2 examples are the Income Tax Act and the Tax Administration Act. So these terms have been defined by case law, by the common law, and so judges seeking to interpret the term serious hardship have precedents that they can fall back on. It is important, I guess, to note, just in sort of global comments in respect of this this particular bill, is that the costs of legal aid have blown out by 55% over a 4-year period. That is something that any government has to address. The previous government that had the means and the resources to be able to do more in this area did a couple of unusual things. One of them was it spent more money in this area by widening the boundaries for which legal aid could be granted. But what it didn't do was it didn't take up at all the legal aid rates that legal aid lawyers were paid. And so what we found when we came into government, that there were a number of legal aid providing firms who were getting out, as the previous member had indicated, and they were getting out because of those levels of remuneration that weren't there. And to be fair, his government did nothing about it in the 9 years that they were there. Now, I accept that what the national government has done now is to restrict access to legal aid in some areas, but at the same time it's extended in others. And where the initial premise of restriction or constraint has been promoted in a bill, and there has been submissions made against those constraints, we have responded by way of folding those back, and a previous speaker mentioned that too, with respect to the filing fee moving from $100 back to $50. So I can understand that there will be members of the House who won't be voting for this legislation. I understand that. I hope that they do reconsider that if that is their current standpoint, bearing in mind that they even accept in rather derisitory terms then some improvements have been made. I believe that it is a bill that will ensure ongoing sustainability of legal aid. I don't expect that in a sector that is bound up in convention and tradition that we're going to have huge accolades for changing anything until those changes have been proved to be worth their salt. Thank you.
Mr Chairman.
I call the Honourable Philip Goff.
Mr Chairman, I want to pick up